Common law intoxication. It's called Vehicle and Traffic Law 1192.3, but that doesn't matter to you. Today, most cases involving DWI, criminal charges, involve a chemical test reading. But what happens if there's no chemical test reading? Does that mean you can't be prosecuted? Clearly not. Before computers, before the internet, before Instagram, there was no chemical test. Have you ever been to a party or a social event and you say, gee, that person's really loaded? That's common law intoxication. It's defined by law in New York State, incapable of operating your motor vehicle as any other sober, reasonable, prudent person would do so. How do they prove that? Well, they look at what's called the classic indicia or indications of intoxication. Unsteady on your feet, slurred speech, your motor coordination, your stumble, your sway, you're not thinking clearly, your smell of alcohol, there's alcohol in your breath, your eyes are bloodshot, you have difficulty thinking clearly. Those are all signs of common law intoxication, and they use circumstantially to prove that you're drunk or intoxicated. But the legal definition requires much more, and only an experienced DWI New York attorney would know that. The legal definition is incapable of driving your car as anyone else would be. Incapable is a very high standard. It doesn't mean that you're a little off. It means you couldn't drive your car. That's what they have to prove you guilty.